All right, welcome everyone to Ethics for Lunch, March edition. Just give me a second to start sharing my screen, and then we will get started. All right, is everybody seeing the presentation, like a full screen of the slides now? Any panelists can say yes or no? Okay, yes. All right, thank you. So thank you everyone so much for joining our ethics clinical case rounds, Ethics for Lunch. Today I am joined by Susan Longley, Allison Smith-Mitchell, Jeff Natterman, and Shirley Waite, and our discussion is going to be on pursuing guardianship of hospitalized persons. So if you'll just review the slides that I'm going over regarding the CME information. So if this is your first time in attendance at one of these, you'll have to initiate the information to get your CME credits. Deja is going to put the information in the chat so that you will know how to do that. All right, and the information is now in the chat. Oops. Okay. If you're interested in joining upcoming events, you can click on this link to get notifications. All right, so I'm going to begin by presenting our case for today. But before I do that, I would like everybody to please, on the panel, to please introduce themselves and their title here at Hopkins. So as I said at the beginning, my name is Molly Selmanoff. I am a clinical social worker on a med-surg unit, and I'm also a member of the ethics committee. Shirley, could you go next?
Hello, I'm Shirley Waite. I'm a lead social worker in med-surg at Johns Hopkins Hospital, and I serve as the social work guardianship liaison between social work and the guardianship team, Susan Longley, and our outside counsel.
Susan?
Hi, I'm Susan Longley, Senior Counsel for Johns Hopkins Health System, and I have the pleasure of being the gatekeeper for guardianships.
Jeff Natterman?
Good afternoon, everybody. I'm Jeff Natterman. I'm the Chief Risk Officer for Johns Hopkins Hospital. I'm Senior Counsel for the health system, and I'm also a member of the Johns Hopkins Hospital Ethics Committee.
And then Allison?
Hi, good afternoon. I'm Allison Mitchell. I'm a clinical social worker with the adult palliative medicine team, and I'm also a part of the hospital's ethics committee.
All right, and thank you all so much for joining today. Oops. Okay, I have no disclosures. All right, so the presentation objectives are to understand why guardianship is obtained, to describe the criteria for guardianship, and to discuss when an ethics consult may be beneficial to the team and the family in the guardianship process. So this is our case for today. AL is a 45-year-old male admitted with a past medical history of HIV and esophagitis who presented after being found down. He was intubated upon arrival and transferred to the medical intensive care unit. Over the first few days, social worker attempted to locate family without success. The medical team attempted extubation, but the patient did not tolerate it, so the team began to consider tracheostomy and PEG tube placement. Both procedures were considered elective, though necessary in the near future to decrease potential damage from prolonged placement of nasogastric and endotracheal tube. So some questions to consider that we will be talking about are what criteria are used to determine what criteria are used to determine if guardianship should be pursued? What is the guardianship process? How long might it take to obtain a guardian? What do you do if members of the multidisciplinary team disagree regarding the need for guardianship? And when should the ethics service be consulted in a guardianship case? And now I'm going to turn it over to Susan to talk about the overall guardianship process in the hospital.
Sorry about that. Not going as smoothly as I had hoped. Hang on. Are y'all seeing this or not? You are. Okay. All right. Let's see if I can make it. If I can get back to. Nope. Sorry, guys. All right. We'll get back there. Okay, here we go. I think. All right. Hopefully you guys can see that now. All right. So just again, I do not have any disclosures. The objectives for this presentation are guiding principles for guardianship, types of guardianships, and just our general practice for pursuit, and the reasons that a guardianship of person or property may be needed. So guiding principles, only requests involving a patient who is currently admitted to a Hopkins hospital can be considered for a guardianship. Although there are a lot of people who don't have anyone to make decisions for them, and there are a lot of people out there who lack capacity, if they're not in a bed in one of our hospitals, we will not pursue, we don't have standing to pursue guardianship for patients who are ambulatory or those who are in need of a procedure on an outpatient basis. So there are two different types of guardianship. The first is guardianship of person. So it's the personal decisions, right? It's medical decision making. It's basically what's going to happen with that person's body. That's a guardianship of person. A guardianship of property is just what it sounds like. It's what's going to happen with an individual's assets, financial assets. So historically, Hopkins would only pursue a petition, or would only petition for a guardianship of person. And that was only in the instance when there was no one to make medical decisions for the person. The person had been certified as lacking capacity, and there was no one to make decisions, and there were medical decisions to be made. That was the only reason that we would pursue a guardianship. But over the years, things are social, the life is much more complicated. The social strata is much more complicated. And we have expanded reasons for pursuing guardianship, and we've begun including guardianship of property in addition to guardianship of person. So some of the reasons that we would petition for a guardianship, as I said previously, healthcare decision-making. So that's when the patient has been certified as lacking capacity under Health General, the Healthcare Decisions Act, and does not have anyone who exists or is able or willing to make decisions on their behalf. Another reason is this might be a guardianship of person and or property, could be needed for discharge planning purposes. So we have a patient who's been certified as lacking capacity or is believed to meet the definition of a disabled person pursuant to the Estates and Trust article. And they don't have anyone who exists or is willing or able to participate in discharge planning or approve the discharge plan. And last but not least is discharge placement. So a guardian of person and property may be needed for discharge placement. And this is when someone is certified as lacking capacity or, again, is in need of, meet that definition of a disabled person. They could have someone, they actually could have a decision maker who's willing to make their healthcare decisions, but no one has legal access to the patient's assets. And the patient needs to go someplace other than home. We have a problem with getting a facility who's willing to accept the patient unless there's someone with the authority to promise that they'll get paid, right? So, that is another reason why we would pursue a guardianship. So I mentioned disabled persons. So the term disabled person is used for both types of guardianship, both person and property, but they're not exactly the same. It's not exactly the same definition for each. So this slide is kind of busy, but it's really talking about the definition of a disabled person for a guardian of person. And that would be, since we're talking about adult guardianships, right? So this would be a person other than a minor, so someone 18 or older in Maryland who's been judged by a court to be unable to provide the person's daily needs sufficiently to protect their health or safety due to the fact that the person lacks sufficient understanding or capacity to make or communicate responsible personal decisions. And that could be due to mental disability, disease, I love these terms, habitual drunkenness, or addiction to drugs. And because of that, requires a guardian of person. Now, it's a little bit different for a guardian of property. So again, we're talking about the definition of a disabled person, but someone other than a minor, 18 or older, okay, who's been judged by a court to be unable to effectively manage the person's property and affairs due to, and here it's physical or mental disability, disease, due to a physical or mental disability, disease, habitual drunkenness, addiction to drugs, but they've added imprisonment, compulsory hospitalization, meaning probably an involuntary psychiatric commitment, right? Detention by a foreign power or disappearance. And because of one of those things, requires a guardian of the person's property. Now, when you're talking about a guardianship, we don't take it lightly because really we are, and the court truly doesn't take it lightly because you are taking away fundamental individual rights of self-determination. So one of the things that has to happen is we talk about a due process. So before a court would take away someone's right to make personal decisions or to control their property, then they have to be afforded due process. And that includes they get notice, they have a right to counsel. And so there's always a court-appointed counsel that represents the alleged disabled person. They have the opportunity to be heard, so there's a hearing. There are fair procedures. People get service of process. They are served and they're notified. Any interested persons are served and notified of the hearing. They have the opportunity to present and also be heard. And then even when there is a decision by a court, there's always the right to appeal. If we are looking for a public guardian, so if there isn't any family or friends who are interested in stepping up, we are pursuing a public guardian. And just for information purposes, if the patient is under 65, then the public guardian would be the Department of Social Services. If the person is over 65, it would be the Department of Aging. And then last but not least, just talking a little bit about timing. If there is really an emergent medical decision to be made, then we still are somewhat successful in getting hearings within maybe 72 hours, but it has to be truly an emergent medical need, medical decision that is needed for that to happen. And that usually results in a temporary guardianship, which could be converted to something more permanent. But again, there's an emergency track. That's when there is an emergent decision that needs to be made. There's also an expedited track, but you have to show that there really truly is a need for speed. So it might be maybe not an emergent medical decision is needed, but something that is time sensitive. Okay, that usually is still happening 7 to 10 days, maybe 2 weeks. But I think the majority of our cases now are falling within the regular track. And those, when I say regular track, those are the ones that are really related to discharge planning and discharge placement. And the court looks at a patient sitting in a hospital bed as being in one of the best places that they possibly could be. They're in a safe place. And the court, despite our effort to get them to hear these cases faster, they're not. And for a regular track, it can take a couple of months. And we are seeing more and more that these hearings are being scheduled 6 to 8 weeks out. So I think that's all I have at the moment.
Thank you so much, Susan. I really appreciate it. Thanks for giving us such a good overview of the guardianship process for when we have patients in the hospital that need guardianship of person and or property. Next, I'd love to have Allison speak a little bit about how you may be involved from the palliative perspective and then also with your social work background.
Sure, absolutely. So I think, specifically from a palliative perspective, but also from a palliative social work perspective, while this process is happening, so while the team's identifying if this person needs a guardian, while they're working with our risk management colleagues on the guardianship paperwork and process, I think in parallel to that, we can still, and we should still have conversations at the bedside with the patient as able, and continue to look for decision makers, look for people who may be out there who can speak for this person. So kind of wearing more of my social work hat, doing as much as able a full assessment. What's some information that we can pull in the chart if we know this person's identity? Can we find any old notes that might have some addresses or might have some names and phone numbers that we can reach out to? If we aren't able to locate anyone, working really closely with our security colleagues here at the hospital they've been really excellent in helping us as the clinical team track down family members, friends, others who may be associated with the patient. And so those are some of the things that I would look for in the chart, specifically related to decision making and to really hearing more about who is this patient and what would they want or not want as part of their care. I think, a couple important things for this specific situation is, it says that this person is intubated, but, we know intubated doesn't necessarily mean that they can't communicate with us. Someone can be intubated and still have, creative ways to communicate either through writing or through letter boards. The units do a great job of finding other tools to communicate with someone. Perhaps, they remain intubated and we know that they don't have capacity based on the assessment. However, if they are still able to communicate, we can extrapolate some information, and try to really meet them where they are here, and as much as they can tell us about, who they are, who are the people in their lives, and thinking specifically about, about goals of care and decision-making, again, all happening in parallel as this guardianship process is going along. And so those are some of the first things that I would think about, again, as a social worker, but also as a palliative social worker while we're working on identifying who can speak for this person. Thank you.
Thank you. Thank you so much, Allison. I'm going to go back to sharing my screen to look specifically at this case and kind of how we would work through this case specifically, and then also get some insight from Jeff and Shirley. Okay, so if we go back to the case, that this is a 45-year-old man who was admitted with past medical history of HIV and esophagitis, was found down. He was intubated. And as Allison appropriately mentioned, that doesn't necessarily mean that they cannot communicate. And that in the first few days, social worker attempted to locate family without success. That really goes back to what Allison was speaking about regarding working with our security colleagues. And then also, being kind of putting on our investigator hat and looking through old notes. Sometimes there might be a chart that is merged or that needs to be merged if they came in under a DOE name. And so really trying to figure out if there's any way we could find a family member. That being said, as Susan mentioned, even if we find a family member, they might not either want to speak on the patient's behalf or be able to. And so even when we do find family, that doesn't necessarily mean that we don't have to go for guardianship. We oftentimes do. And as Susan was saying, with regards to discharge planning, more recently, because the post-acute facilities need to know how they're going to get paid, we oftentimes will need to go for guardianship of property in addition to guardianship of person, because otherwise we cannot safely discharge the patient. So regarding the extubation, I think the important part in this sentence is that is the tracheostomy and the PEG tube placement, because they are both considered elective. Now, there certainly could be times where they are needed more emergently, but in this situation, they were considered elective. And so we want to decrease the potential damage of them, but those cannot be done without a guardian. So Jeff, I'm wondering if you can speak a little bit about in situations like these, when ethics has been involved, either in a situation like this or in something, maybe adding a part that makes it even more ethically complex.
Wow, I appreciate that, Molly. Before we get to the ethics piece, there's one or two, I think, really critical points to the case study, but also a very common question we get from social work and the clinical team. And just by way of background, we have a 24/7, 365 attorney on call. And we get probably, I want to say, after tracking for about a year, 50% of our calls are informed consent related. Give or take. And so this comes up a lot, actually. And the specific thing that comes up often is we don't have a consenter and we have certified the patient as lacking capacity. And there's a whole discussion about what it means to certify incapacity, by the way. But let's just assume here that the patient is incapacitated, is certified by two licensed physicians in the state of Maryland. Who consents? And so the question we often get is, can two physicians sign the consent form for the patient to do the trach and the peg? Because there is nobody. And I know I can sense Susan right now getting this call, and both of us having these conversations in the past, because we've been trying to dispel the myth that it's ethically and legally permissible for two physicians to consent on behalf of the patient they're about to operate on. And that is not correct. It's not legally correct, and I would argue it's not ethically correct for them to be able to do that. Sometimes you can get an ethicist involved in that, but it's a hard no. Two physicians can't consent for a patient that they're treating by signing a consent form and agreeing to risks on behalf of the patient. That's just a non-starter. So that's a question we get a lot, is what do we do in the meantime while waiting potentially to find somebody or to go down the guardianship route? The other really significant piece to this is, in Maryland, there's an emergency consent statute. And I think this is where some of the confusion comes in with the two physicians signing consent for the patient. You have two physicians that have to certify the patient lacks capacity. And if they do that, then if there is a life and limb emergent situation with the patient, and there are certain elements that have to be demonstrated here, you can proceed with a procedure for the patient without consent. So that means you don't sign the form, you just do what you got to do to save the patient's life, because time is of the essence to prevent death or serious injury to that patient. You've tried to find somebody and can't. And then the third major element here is wasting time to try to find somebody would cause the patient death or serious injury. Now, we don't request that the providers write all that out in the chart before they take them to the operating room as a level one, but they have to be able to demonstrate in good faith that was the situation at the time, that they did a procedure to an incapacitated patient with no consent. And then if it's not emergent, this is where things get really fuzzy fast. If it's not an emergency, if it's an elective procedure and you don't have anybody to sign consent and the patient can't sign their own consent, we're a little stuck. The law doesn't allow us to just, do things to patients without the appropriate consent process after assessments. And so there is that kind of gray area which says you really can't trach or peg unless it's emergent. And I just said what the definition was of the emergency. And sometimes that rankles or upsets some of the clinicians. And so this is sometimes where we get into the ethical dynamic of what's happening with the patient, not just from a legal point of view, but you will often get the questions or arguments that this is not ethical to make a patient wait to find somebody to do something that we think is in their best interest. So I'll stop there and see if anybody has any additional thoughts or questions about
that. Jeff, could you speak a little bit about kind of when ethics is consulted on a case like this, where kind of, as you explained, the ethical or the medical team has concerns that it is unethical? Do you kind of bring it back to the legal standing that if it's not life or limb, it cannot be done? Or are there other ways in which you contribute to that conversation?
So that's from a legal point of view, the law is pretty, I want to say, cut and dry for the most part. You have the Healthcare Decisions Act, which says these are the do's and don'ts. And so as a lawyer, we are obligated to follow the do's and the don'ts and then advise that to the clinical team. There are, of course, situations where there's moral distress in these circumstances by the clinical team, where you would say, maybe we should have an ethicist involved here. But I will also put out there that one of the big questions the ethicists ask is, what's the ethical question? because sometimes it's unclear, even with the clinicians, as they're going through these situations, what is the ethical question that you're trying to ask that needs to be solved by having an ethics consult or talking to the ethicist? I mean, I'd love to hear from the ethicist. I mean, we talk a lot about that too, often as we curbside each other, as we're getting these questions. And often we'll try to figure out or suss out what the ethical question is here. And sometimes it comes down to staff moral distress. Like, it bothers me that we know the fix and we can't do it legally. Don't we have an avenue by which we can pursue doing what we think is in the patient's best interest? And that's what leads to clinical team discussions with ethicists and legal at the table to come up with a goal of care, to come up with a strategy for trying to get what the patient needs while not violating the Healthcare Decisions Act. I mean, there are certain immunities that attach with following the Healthcare Decisions Act. There are also avenues that can be taken in some situations where it may not comport with the black letter of the law there, but as long as it doesn't breach a standard of care, there may be a way to do what we need to do for a patient that follows the standard of care. And that component of the discussion is typical for things like end-of-life decision-making and doing procedures or not doing procedures that may be asked for by the clinical team or even a family member that would not be appropriate based upon the standard of care. It gets very gnarly fast sometimes with some of these situations.
Allison, to put you on the spot a little bit, does anything come to mind when Jeff was mentioning situations where things get gnarly pretty quickly, or if there's a spin on the case, like let's say the patient, they were concerned that the lack of, I don't know, the NG tube kept getting displaced, and so the PEG tube was really the best option for nutrition and and then how we sometimes get consulted and kind of where we would go from there.
Sure. So I guess I have a couple of thoughts, and I'm spinning the case a bit, but I think it's something that's important to remember. And so if we spin the case where if the gentleman has questionable capacity or maybe waxing and waning capacity, really doing certainly that full capacity assessment, but also remembering that patients have autonomy and the right to make poor decisions, or what we define as poor decisions if they have capacity. Knowing that there has to be a full assessment of capacity done, but that's something that I think about in these cases. Is the capacity to make decisions, but also, they also have the capacity to make, perhaps what we would say is an unsafe decision. And again, I kind of really think about, and something I know we've talked about in other ethics consults that are similar to this case is, as a clinician myself, I really find that I can ground myself in the law of what does the law say, certainly leaning on our colleagues for support and guidance, but really grounding our work in the law, and letting that guide what is the right next step in terms of these really sticky cases. So those would be the two things that I would think about in this case. And just one last thing, again, I'm making a lot of assumptions and changing the case a bit, but I can't emphasize enough also doing the really good chart dive if we have the luxury of having a chart. We had a case recently where that was called to the ethics committee, and we weren't able to locate, or the team wasn't able to locate the decision maker. There was discussion of guardianship. A medical decision need to be made. So we were looking through the chart and how has this patient made medical decisions in the past? What have been are there any kind of patterns that we're seeing in what this person has done or not done as part of their healthcare? Again, just to help drive decisions as we're moving forward. I'll stop there. I see Susan's hands up.
So actually, you touched on something that I was going to say, and also just going back to what Jeff said. So being able to proceed without consent, in an emergency, but an element is also the fact that you can't proceed without consent to perform a procedure that the patient has otherwise said in the past, expressed in the past that they didn't want. So it's kind of like looking at what you were talking about, diving into the record. It might not be in a question of whether or not we can proceed without consent and it's an emergency and can we proceed without consent. It might be the question of really what would the patient want. And if we have a lot of patients that are come back to us frequently. So we have a lot of documentation in our records related to their choices in the past. And that obviously could give some evidence that there could be there could be an ethical issue or a dispute about what would the patient want. If the patient's not able to make that decision for themselves, and what have they wanted? Have they been presented with the idea of having a PEG in the past, or they've had an episode where they were vented for a long period of time, and there was a recommendation to have a trach done. So anything that the record can reflect what the patient's wishes might be certainly could give rise to an ethical dilemma and a question. And then we see it all the time when the team disagrees about whether or not the patient truly lacks capacity and doesn't have the right or the ability to make a given decision.
Mm-hmm. Yeah, thank you, Susan. And I think kind of going off of what Susan was saying, we could change this case in so many directions and then think about, we could have a whole conversation on surrogate decision makers. And let's say we actually did find a decision maker, but then, and looking through the record, the patient has said that they would not want a trach in the past, but the decision maker now says, oh, well, we do want a trach. So I think we could definitely spin this case in a lot of different ways. I want to go to Shirley next and then to you, Jeff. Shirley, from a logistical perspective, being like the go-between for social workers who are usually the ones on the ground pursuing the guardianship, and Susan, and then our outside counsel, what are the main steps that have to be achieved from the beginning of determining that guardianship is necessary up until the court case?
So I think Allison gave a good description of some of the initial things, because we really want to do the most complete assessment that we can, and to follow every lead that we have in terms of like seeing all the things that you mentioned, trying to see if we have any history on the person themselves, if we can find out from family, if they knew anything about the person's, what was important to them, if they had an advance directive, or, if they have anything in writing. And once we kind of do all that, then we usually will try to bring the case to Susan Longley to give her kind of like a synopsis of this is where things are. This is an incapacitated patient. These are all the avenues that we've tried to find somebody who would be willing and able to make decisions, and to ask permission to move forward to go towards court. If we get that okay, then the next thing we're doing is asking for 2 physician certificates to be filled out. So it would be 2 licensed doctors who have seen the patient and are willing to talk about what they see in terms of how the person is or isn't able to make decisions for themselves, and what's causing them to have those needs. Like, is it physical symptoms? Is it mental illness? Is it dementia? What are those reasons? And And then we also get information from the social worker about the demographics of the case and the social and family context that the person has. Put all that together, send it in, and then it gets forwarded over to outside counsel. Once we have all the corrections made, which can take a long time, actually. And Susan is smiling because she knows about all that. Then we'll wait for a court date. Depending on the case, it can either be short, although we haven't had that recently, but I'd say, like, perhaps in this example, this might be a case where, you know, we might be able to get the guardianship done in a few days or a week or two. Susan can comment on that more. Since it sounds like there's, you know, like medical urgency to the decisions being made. We can't really wait for months to be able to figure this out without, you know, possible harm coming to the patient. Then we prepare for the court hearing. So I don't know if you want to go into all that now or just wait for now.
Sure. Thank you so much, Shirley. I appreciate it. Kind of piggybacking off what you were saying with the medical urgency here. I totally agree that if there are these medical decisions that need to be made, that definitely has more urgency than our cases that take a couple months before we get a court date. Now, just for, you know, individuals who are viewing, if there was not a medical decision that needed to be made, but they needed the guardianship for placement and for somebody to pay for the placement, we have actually been pretty strategic, I think, more recently in figuring out ways to get patients discharged from the hospital before the guardian is actually appointed. So I will defer to Susan and Jeff for some of this, but I think just briefly in my experience, if there's a family member that we have found and is willing to make decisions on their behalf, they can approve for the patient to discharge from the hospital to typically an assisted living or to a skilled nursing facility. And so we have to get approval from the family for the patient to discharge. And then whoever the accepting facility is, more recently, it's been more assisted living facilities. They have to agree to co-petition with Johns Hopkins and to have our outside counsel represent them. I think what I've noticed is important to mention to those facilities is that there is no financial contribution that they need to make, and that they are not being, we are not requesting that they become the guardian. We are only requesting that they work with us and that they also agree this patient needs a guardian. And then as long as those two things are done, that there is a family member who agrees with, you know, discharging from the hospital to whatever location, and then that the facility they go to are willing to be co-petitioners with us, then we are able to discharge patients and not keep them hospitalized for the potential 2-month wait until the court date. Shirley, did you have something you wanted to add on that?
Yeah, I just wanted to say that the other piece is that in addition to like having somebody in the family to make decisions, you also have to make sure that everyone in the family or all of the interested parties agree, because we've often had trouble with that, where, you know, one person wants to be the guardian, another person does not want that person to be the guardian, or that they have completely different ideas about how the care of the patient should go moving forward.
Thank you. Yes. Jeff, was there something you wanted to add from previously?
You know, you said something about surrogate decision making and finding the right person and being able to talk for a while about surrogate decision making. So it's almost not relevant for the rest of the conversation. Just that oftentimes, you know, we get calls and questions about the whole hierarchy from the healthcare agent and then all the surrogates down to close friend and other. And I wanted to just, share that, and I think colleagues would agree that the preference would be, and I think with the court as well, that a family member somewhere in that hierarchy is willing to be the guardian, although oftentimes the family's not willing to be the guardian. But likewise, in another respect, sometimes the family wants to be the guardian, but maybe shouldn't be. Because of what Susan was saying earlier about there are criteria for what's in the patient's best interest, what the patient wants, and a whole lot of elements that have to be thought of when you're picking the guardian. And sometimes there can be an ethical conundrum if you've got like a sister, a brother, a wife, a daughter, somebody that wants to like continue making decisions, but they're really making bad decisions, like on behalf of that patient based on what they want and what the standard of care is. And so I just wanted to throw that out as another nuanced element of when we're talking about guardians, it's not as easy as just saying we'll get a public guardian or we'll just use the sister, that kind of thing.
Yeah, so that is a conundrum often where we will have family and we are in essence putting on a case to the court that we think that the individual is not acting in the patient's best interest. So when we have the conversation about should we pursue a guardianship, I always say, be careful, be careful what you wish for, because what you may end up with is the spouse who we believe has not been making decisions in the patient's best interest being appointed by the court now as the guardian of the person. And you have the same issues all over again. Going back to what Molly said about some of our changes in practices and the fact that we are trying to get patients out before the guardian is actually appointed, just to clarify that. Remember in the very beginning, I said we only do petition for guardianships for inpatients. That's because we have to have standing, which is, a legal term to bring a case, right? And so the way this works for a guardianship is we cannot discharge the patient until we have actually petitioned. And then once we have petitioned, it may be between petition and hearing that the patient is discharged, but we really are no longer an interested party once the patient is discharged. That's why we have to ensure that there is someone who picks up the mantle, so to speak, and becomes the petitioner and sees it through. And Molly was saying that there's no financial obligation on the part of the facility that receives the patient. That's because Hopkins has taken the position that we will assume that responsibility regardless. And interestingly enough, we really don't have a legal obligation to do that, right? But we're trying to facilitate appropriate placement for folks. So we have, we said we would assume responsibility for petitioning for guardianship. We were assuming that financial responsibility for the petitioning. But in order to get the patient out the door, we will, we meet that obligation from a financial perspective as well. So, not really legally required to do it, but we're still doing it.
And I would say that it seems that the guardianship cases where we have our physician testifying and sometimes also a social worker testifying really shows to the court that why it's necessary for a guardian, which I would imagine the case might not be as great if those steps weren't put into place beforehand, which can be helpful.
Well, and we have, if you think about it, especially as I was saying, we see patients come back frequently, right? And so it may be a situation where we were able to get a patient discharged, but we've learned that they're going to be back and that we're going to have the same issues all over again. So we try to, we go to court and we try to ensure that there's that safe infrastructure around the patient. So in the event they do cycle back to us they decompensate and they have medical issues again, at that point, though, they will have a medical decision maker and someone who can participate in discharge planning, et cetera.
Thank you. Our viewers have been very quiet today. I'm wondering if anybody has any questions.
I do have a question, if that's okay, while we're waiting for others to come
Yeah.
in. Susan, I have a question, I guess, for you and for Jeff. If a patient's admitted to the hospital, we will sometimes hear from family members or through the chart, hey, I'm the surrogate decision maker, or I'm the wife or the fiance. We've also had cases where someone said, I'm the guardian. What type of paperwork, what should we be getting from that guardian to confirm that, just like we would collect an advance directive, again, to make sure that we have things properly documented and have our ducks in a row. So what should we be asking at bedside and what should we be collecting from that person?
You want to take it, Jeff? You want me to?
Oh, why don't you go ahead, Susan? I got ideas, but I would love to hear what
We
you
have ideas. Well, so when you have someone who's presenting and telling you that they have a given relationship, and it's based upon a document or a court proceeding, the expectation is that you're not really that until we're presented with the court order naming you as the guardian of person, or guardian of property, guardian person, guardian of property. So we need a copy of the court order. And the biggest reason really is the order itself will delineate the authority of the guardian. So just saying I'm the guardian of the person doesn't really tell you what their authority is. The order gives you what their authority is. And for most folks, when a guardian of person is appointed, they typically do not get end-of-life decision-making authority. So the only way that they get that is if at the time the petition is filed, it is foreseeable and it's specifically requested, or you may be the spouse or someone on the surrogate hierarchy who would otherwise potentially have that authority pursuant to surrogate decision making. Okay, so you need the court order. And then the same as with a guardian of person, when people tell you that they're the power of attorney or the healthcare agent, we see a lot where our rank and file will use those terms interchangeably, and they're not exactly interchangeable. A power of attorney historically has been a general business power of attorney. So kind of like that guardian of property who can buy, sell, do all kinds of business type decisions on behalf of the individual. You could have a medical power of attorney that is in essence like an advance directive, naming a healthcare agent. And again, you need the document so that we can actually see that the criteria that make you that a healthcare agent or make you a medical power of attorney, that it meets criteria and it's legally valid. And also, whether or not the document may also kind of delineate what the patient wants done in certain circumstances. So.
Jeff, anything you wanted to add? That was a pretty good explanation. Thank you, Susan.
Yeah, Susan's amazing. And I mean that, not just being obsequious. I completely agree with everything she said. And gosh, Susan and I talk multiple times a week about this stuff. The only thing I would add to that is often we'll get a situation where on the hierarchy, somebody will say, well, I'm the wife. We don't question by asking for a marriage license if they say they're the wife. It's a rebuttable presumption. In other words, we presume you're telling the truth and you're the wife or you're the daughter. Now, we have had situations all of a sudden where somebody was a girlfriend and purportedly a domestic partner, and we didn't question that, and we're entitled to take it on faith that they say they're the domestic partner until the wife shows up. And then now we got a problem because you have a wife who has a marriage license and can prove it, and the girlfriend goes away or the boyfriend goes away now. That's why healthcare agency becomes a critical thing and a really good tool for people when they want to designate somebody to make decisions for them. Because honestly, in that situation, had the patient made the girlfriend the healthcare agent, then she would have been the decider over the wife. And there are countless nuances in the hierarchy of those types of presumptions. And this is what we get called a lot about. So Susan's absolutely spot on with the healthcare agent and the guardian. You have to have that document to show that you are that person. And then also at the very bottom of the hierarchy is the next friend or the close friend, where you need an affidavit to demonstrate that they're willing to make those types of decisions for the patient. It's the in-between patient, the in-between people between the spouse, domestic partner, adult children, parents, adult siblings, where we have those presumptions that set in until it becomes an issue. And oftentimes ethics gets called in to help resolve disputes with people in that same line when they don't agree on decision-making for that patient.
Jeff, I'm wondering if you can also answer the question that just came into the Q&A, which is, when can a family member make decisions and when can they not? And then kind of a secondary question to that, and what leads to the need for a guardianship when there is family present?
Oh goodness, we're going to need another hour.
Why don't you maybe answer the first part as quickly
Sure.
as possible?
As quickly as possible. And thank you. Was it David who asked that question?
It was anonymous.
Oh, okay, fair enough. So when can family make decisions? It depends on the patient, right? So the patient actually can appoint a healthcare agent effective immediately with decision making. Now, it doesn't trump a patient's with capacity, their ability to make decisions for themselves. So the document controls when a family member can make decisions if they have a healthcare agency. And also families defer to, the husband, the wife all the time, let them decide for me, and they can do that if they want. So I think you need direction from the patient as to what they want to have happen in terms of decision making. Now, there are patients that are completely against that and make their own decisions until they lose capacity. And if they lose capacity and they're certified as having lost capacity, then under Maryland law, you have to go to that hierarchy, start at the top, and then work your way down till you find the appropriate legally authorized decision maker.
Thank you, Jeff. Thank you. That was very short and sweet. Thank you so much. I want to thank all of our panelists so much for being a part of our Ethics for Lunch conversation today. Jeff, Allison, Susan, and Shirley, thank you so much for dedicating time and commitment to this presentation, all the work leading up to it, and to continuing to work with our patients in the hospital who are in need of guardianship. If you have any questions afterwards, I believe Deja Thomas would be the person to contact. She's put in the information regarding the CMEs, and you're also welcome to reach out to me if I can answer any questions. I'm the only Molly Selmanoff at Johns Hopkins, so my email is mselman1@jhmi.edu. And thank you all so much. Have a good rest of your day.
Thanks, Molly.